Next, let us proceed on Chapter 3 of RA 9285. So, Chapter 3 of RA 9285, it is all about the other ADR forms. Okay, so nandito, it is now on Section 18, sabi dyan, referral of dispute to other ADR form. Okay, so yun, it is not practicable to undergo mediation, kaya pwede naman yung mga parties natin dun sa dispute na yun can agree, okay, or may be referred to other ADR forms. So, ano yung mga example nun? Na-mention dyan, the evaluation of a third person, okay, or yung E&E na tinatawag natin, okay, that was discussed the last time. And then we have here, the next one, it could be also a mini trial. Na-discuss na din yan on our previous recordings, and or it could be also through mediation arbitration. Okay, mediation muna and then it will undergo arbitration. Okay, if it is not solved through the process of mediation, or if not, the combination of mediation or arbitration na ito na sinasabi natin. Sabi dyan, for the purposes of this act, the use of the other ADR forms shall be governed by Chapter 2 of this act. So, yun yung mga napag-usapan natin kanina, Chapter 2. And then, exception dyan, where it is combined with arbitration, so, yung third na na-mention natin kanina, mediation, arbitration, combination thereof, yung mag-govern naman doon is yung Chapter 5. So, yun ay madidiscuss natin later on kasi nandito pa lang tayo sa Chapter 3. Now, we are going to proceed on Chapter 4. And Chapter 4 of RA 9285, it is all about international commercial arbitration. So, let's start on Section 19. Section 19, it is all about the adoption of the model law on international commercial arbitration. So, take note, as we have mentioned the last time, model law was created in order na meron tayong basihan, yung mga different states na merong silang basihan in creating their own arbitration laws. Okay, so with that, yung RA 9285 na ito, yung mga provisions na meron tayo dito, nakuha natin yung mga provisions na yun in some part of the model law na ito. Okay, so yan, yung model law that was agreed upon June 21, 1985, and it is approved in December 11, 1985. So, now we are going to proceed on Section 20, and in Section 20, it is all about interpretation of model law. So, in interpreting the model law, it says the regard shall be had to its international origin and to the need for uniformity. So, it mentions here uniformity. So, parang kung ano sana yung interpretation natin, kung paano natin i-interpret yung model law dito sa Pilipinas, it is the same with the member state also, with the other member state. Okay? Kung paano nila i-interpret. Okay? So, yung member state na tinutukoy ko, it is on the New York Convention. So, yun, dapat parehas yung pag-interpret natin ng model law. So, sa Pilipinas, ganito natin i-interpret, ganun din dapat sa other member states such as the US and Australia and other places. Okay, so that is what is being emphasized here in Section 20, uniformity of interpretation. Okay, and then on Section 21, we have your commercial arbitration. So, paano ba natin masasabi na it is classified as commercial? So, sabi dyan, arbitration is commercial if it covers matters arising from all relationships of commercial nature, whether contractual or not. Okay, so, yun, any conflicts or any disputes that are being solved through the process of arbitration are considered commercial arbitration. Okay, any conflicts that exist between business establishments, okay, or companies such as companies that offers goods and services such as manufacturing companies, mga yon, any disputes that are being resolved in the process of arbitration, we term it as commercial arbitration. So that is what is defined under Section 21, all about commercial arbitration. Next one we have here, Section 22, legal representation in international arbitration. So, sabi dyan, pwede naman po tayong mag-select ng kahit sinong tao, okay, na pwedeng mag-represent sa atin in international arbitration, especially if we are involved in international disputes or commercial disputes that involve foreign state. Okay, so yun, pwede tayong mamili kahit sino. Yun nga lang, kailangan din nating tignan nito kasi meron dyan yung hindi pwede. Sabi dyan, the person that we choose should not be authorized to appear as counsel in any Philippine court. So he's not currently taking over or inaasikaso, okay, in a Philippine court or in any quasi-judicial bodies, okay? So, such as the Office of Mediation Center and others, okay? So, hindi po pwede na siya ay mag-represent sa atin in international arbitrations. Okay, so that is what is being said here in Section 22. And now, in Section 23, confidential of arbitration proceedings naman. Kasi doon sa Chapter 2, yung mga nabanggit lang doon, confidential information in mediation process. Ngayon, arbitration proceedings naman. So, sabi dito, so the arbitration proceedings, including the records, evidences, and arbitral awards, or in other words, any informations, communications that was brought out during the process of arbitration, they are all considered to be as confidential. Okay, they are considered to be as confidential information, and they shall not be subject or they shall not be published. Okay, so yan, meron lamang yung mga exceptions dito. So yun, pwede nating may publish yung mga yan, okay, may disclose yung mga yang communications na yan pag meron yung consent of the parties, okay? With the consent of the parties na okay lang kahit na may publish yung mga communications na yan, okay? And then, yan, for limited purpose of disclosing to the court of relevant documents in cases where resort to the court is allowed therein, okay? So, sometimes meron din dito papasok yung discretion ng courts, okay? Na yun, the court in which the action or appeal is pending may issue a protective order to prevent or prohibit. So, meron dito, merong pakialam ang courts, okay? Especially if it is an arbitration that was, sabi natin, court annexed, okay? Merong supervision ng korte. So, pwede niyang i-prohibit or sabihin, i-prohibit na yung arbitration, yung mga communications na nangyari during this process cannot be disclosed. Or pwede rin niyang sabihin na dapat nating i-disclose ito. Okay? It is simply upon the discretion of the court also. Okay? So long as it is not disqualified or it is not being prohibited under this act. Okay? So that is what is being meant under this part. Next one, we have here now Section 24. Okay, so referral to arbitration. So sabi dyan, a court before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if at least one party so request not later than the pretrial conference, upon the request of both parties, thereafter refer the parties to arbitration. Okay, so yun, mention natin din nung mga nakaraang discussions natin na ang korte pwedeng mag-refer. Okay, pwede niyang sabihin, you should also conduct first a mediation process, baka maayos pa ninyo yan. Okay, on mediation para hindi na tayo mag-proceed sa court proceedings natin. So, same as with arbitration. So, pwedeng yung korte magsabi na yan, pwede i-refer ko kayo on arbitration process, or kung hindi man, through the request of a certain party or yung choice ng both parties. So, dyan mangyari or dyan sila pwedeng mag-undergo ng arbitration. Okay? Referral to arbitration. So long as it is not during pretrial, okay? Not later than the pretrial. So, paano kapag nasa trial na sila? Pwede bang pwede ba silang magsabi na, yun, mag-refer na lang pala tayo, we should undergo to arbitration process. So, pwede bang ganun yung mangyari? So, this time, hindi na po pwede kasi ang ruling dyan, at least at later than the pretrial conference. Okay? So, yun yung name-mention dyan sa Section 24. Okay? So, now we have your Section 26. So, under Section 26, it just defines appointing authority. So, ano nga bang ibig sabihin daw nitong appointing authority na to? Simply, appointing authority, we refer to the person or institution named under the arbitration agreement as appointing authority. Okay? Kung sino yung nandun, yung nakapangalan doon na institution or na tao. Okay? Especially in regular arbitrations or the so-called domestic and construction arbitration. Okay? That will be discussed in this session also. Okay? And we have here, how about in ad hoc arbitration? Who will be the one who will be the one to appoint the arbitrator, if ever. Okay, so nandyan yung na-mention, National President of the Integrated Bar of the Philippines or the IBP. Okay, so yung National President, siya mismo yung magdi-decide or mag-appoint ng arbitrator. Okay, and then with that, kung hindi siya available, pwede rin yung his duly authorized representative. Okay, so yun po yung tinutukoy dyan sa Section 26. And then, now we are going to proceed with Section 27. Okay, in Section 27 naman, it is all about the functions that may be performed by the appointing authority. So, yung mga functions po na yan na pwede niyang perform, makikita po yan sa model law natin. Saan? Specific na article, matatagpuan yan sa Article 11, Paragraph 3. So, yung mga nakasaad doon sa Article 11, Paragraph 3 na yan, yun yung mga functions na i-abide or gagawin ng appointing authority na ito. Okay? And then not only paragraph 3 but also paragraph 4. Parehas din sa article 13 and 14. Okay? Specifically in article 13, paragraph 3, yun yung mga functions nila. Okay? Kindly take note of those. And then yun na-mention dito, model law shall be performed by the appointing authority unless the latter shall fail or refuse to act within 30 days from the receipt of the request, in which case the applicant may renew the application with the court. Okay, so yan po yung nandyan sa Section 27. Now, let us proceed on Section 28. Dito naman makikita natin the grant of interim measure of protection. So, in times na medyo merong mga alanganin, okay, or medyo mainit yung issue, and then nalalagay sa alanganin yung safety ng isang tao or security ng isang tao. Okay, so with that, nandyan yung paragraph A. So, ano lang naman dyan yung sinasabi niya, before you seek grant or before you request interim measure of protection to the court, kailangan muna dun ka muna sa arbitral tribunal manghingi ng measure of protection, interim measure of protection. Unless hindi talaga pwedeng mag-release ng interim measure of protection yung arbitral tribunal kasi take note, we are on the process of arbitration na. And then yun, kung hindi talaga pwedeng mag-release daw ng interim measure ang arbitral tribunal, then that's the time you can proceed to the court para mag-request ng interim measures of protection. Okay, so meron dito sa paragraph B, okay, so the following rules on interim or provisional relief shall be observed. So ito, any party may request the provisional relief be granted against the adverse party. Such relief may be granted in the following situations. So yun, purposes, following situations or purposes. So nandyan, in order to prevent irreparable loss or injury. Okay, so merong nagbabadyang threat dun sa tao, kaya gusto niya manghingi siya ng interim measure of protection or para magbigay ng effort ang ating court, okay, na yun, conditions na or security measures para mabigyan ka nun in order na ma-secure while the process of arbitration is ongoing. Okay, and with that, not only to prevent irreparable loss or injury but also to provide security for the performance of any obligation. Okay, dahil dun sa sabihin natin during the conduct of the process of arbitration, nagiging hindi ka na nakakapagtrabaho dahil medyo na merong threat from the other party na nangyayari. Okay, so yun, isa din yun sa purpose ng interim measures na pwede nating hingin dun sa court kung sakali. Okay, and then nandyan din to produce or preserve any evidence para maprotektahan natin. Baka balak nilang sirain yung evidence mo, yung proof na meron ka. Okay, so with that, pwede natin yan ma-prevent through the interim measures that may be provided by the court or the arbitral tribunal. Okay, or to compel any other appropriate act or omission. Okay, para mapigilan natin yung any illegal things that might happen to us while we are availing or while the arbitration process is ongoing. Okay, and then number 3 says, sir, the order granting provisional relief may be conditioned upon the provision of security or any act or omission specified in the order. Okay, so na-mention pa rin yan for security purposes and any act of omission, to prevent any act of commission or omission, in other words. And then we have here number 4, interim or provisional relief is requested by written application. So take note of that, it should be in written form. Okay, if you are going to request for a grant of interim measure of protection, then you should have it in written application. Okay, so yun, to be transmitted by reasonable means to the court or arbitral tribunal. Just take note of that. It should be in written form. And then the order shall be binding upon the parties. Okay, so it shall be enforceable also with the parties. Okay, and then either party may apply with the court for assistance in the implementing or enforcing. Okay, so any party can request interim measures. So hindi po yan na wala pong pinapanigan yan or walang pinipili. Kung kahit sino between the parties can apply on what we so-called interim measures of protection kapag nakikita niya na may badyang threat sa kanyang seguridad and other reasons. Okay, as mentioned a while ago. And then number 7, a party who does not comply with the order shall be liable for all damages. Okay, so sabihin natin yung sinet ng arbitral tribunal na conditions. So, yun, you are not allowed na lapitan si Mr. X. Sabihin natin yung other party kasi ang nag-away, sabihin natin si Mr. X and Mr. Y. So, itong si Mr. Y nag-file ng grant or nag-file ng interim measure of protection, okay, against kay Mr. X. So, yun, sinabihan ng korte or ng arbitral tribunal, wag ka munang or hindi ka pwedeng lumapit within 50 kilometer radius. Sabihin natin, 50 kilometer radius kay Mr. Y. Okay, so yun yung sabi ng arbitral tribunal sa kanya. So with that, pag violate ni ano yan, sabihin natin si Mr. X, pumilit siya, still pinupuntahan pa rin, nilalapit-lapitan itong si Mr. Y, nukulit. Okay, so with that, there is a violation. So, meron tayo dito yung number 7, sabi, a party who does not comply with the order shall be liable for all damages. Okay, if it causes damages, then he will be liable. Okay, and then, any expenses also na effect nung damages na yun, that could be also taken into consideration on Mr. X. Now, dito naman sa Section 29, continuation still of Section 28 or in relation with Section 28, it is on the further authority for arbitrator to grant interim measure of protection. So, meron dito na specify at the end of the sentence, sabi dyan, either party may apply with the court for assistance. Okay, so in times na hindi po kaya ng hindi po sapat yung ini-implement ng arbitral tribunal. Okay, the interim measures that are being enforced by the arbitral tribunal, medyo kulang pa dun, tingin nung party na yon, ng isang party, medyo parang kulang siya. So, yun, he can ask assistance from the court. Okay, so it's either both party walang pinapanigan yan. So, parehas sila, they can avail or they can apply for court assistance in implementing the interim measures that are being implemented or enforced by the arbitral tribunal. So that is being mentioned under Section 29.